The next presenter is Greg Magrooney. Greg's Vermont's traffic safety resource prosecutor. Greg, I couldn't let this go by. Greg did his undergrad work at Penn State. I had a thing there that said something about omit Penn State football joke. And I know Greg has been instrumental in a number of cases where we're still working on DUI issues. We're looking at new technology, not only in the area of DUI, but we're looking at what the admissibility of DRE's testimony in courtrooms is going to look like, where the decrim discussion is going to go, where the legalization process is headed in Vermont, how we're going to deal with that as a law enforcement entity. It's one thing to be able to arrest somebody on the side of the road, but the job is not complete until there's an appropriate resolution in a courtroom. And that's as much as part of the law enforcement message as the initial stop. We have to look at the initial stop, we need to look at the prosecution, and we need to look what happens on the other end. In some cases, we need meaningful treatment, and if we don't have all those pieces together, then we're not doing our job. So, Greg, thank you very much.
Good morning, everyone, and thanks. And Commissioner, just to show there's no hard feelings about any Penn State issues, I did invite the prosecutor for the Jerry Sandusky trial to speak at our summer training for the state's attorneys. So kind of smooth over the rough edges of my deflated beliefs and dreams of my childhood about the purity of Penn State. So I am here to talk to you today about the DUI drugs law, and the conversation gets a little bit technical. So to pique your interest at the outset, I will tell you, and we'll come back to this later, but I will tell you that I've just got back from doing 2 nights of jail in Phoenix, Arizona. So Vermont's DUI drug statute, and it defines a drug as a regulated drug under Vermont's law, or any substance or combination of substances other than alcohol, and I see Representative Lippert here, who's a proponent of, and I think the correct view, that alcohol is a drug, and we're really talking about the same thing over and over when we talk about drugs and alcohol. But it must affect the nervous system, the brain, or the muscles of a person, and this part's important, and we'll cover this extensively today, so as to impair noticeably and appreciably, and this last clause is really the important part, a person's ability to drive a vehicle safely. So I get a lot of questions from people about what are drugs. My God, if I have too much caffeine under this, am I going to run the risk of getting a DUI drugs if I have that 4th Red Bull and a cup of coffee? No, it's not going to happen. If I take Robitussin DM, am I going to have an issue with the DUI drug statute? My answer is not unless you drink 12 bottles because you want the dissociative anesthetic effect of the cough suppressant that's in there. So I think with all of these, it's a question of degree. If anybody has questions as I'm going through, feel free to ask, but I know there's a lot of misinformation about the DUI drug statute and a lot of things folks don't understand, and that includes me. So feel free to interrupt me as questions emerge if you have them. So the criminalization of DUI drugs is found at 1201 of our Title 23, and it's illegal to drive a motor vehicle on a public highway when you're under the influence of a drug or the combined influence of alcohol and any other drug to a degree which renders the person incapable of driving safely. And if we look here, we'll see it again. There's the incapable of driving safely language. It's interesting because it's still illegal to drive even if that drug has been prescribed legally to you and it is impairing. And that's one that a lot of folks struggle with, the fact that if the drug is prescription, it can't be impaired. But as we all know, you've probably gotten a prescription for something at some point where they said, don't drive with this, or they put the little advisory sticker on the bottle. So let's talk about under the influence, because that's the other component here. Under the influence of alcohol, okay, that's better. Under the influence of alcohol are the physical manifestations capable of observation by a witness. And they're also the loss of full control over your mind and your body. So with alcohol, the jury instruction that the judge winds up giving is that you may consider the defendant, or you may find that the defendant was under the influence of alcohol if that defendant is impaired to the slightest degree, and that is any outwardly measurable loss of your mind and your body. So anything that a lay average person would see that would cause that person to conclude that the person they were seeing had been drinking to excess would be sufficient for our purposes under the statute to convict for a DUI. Although, in the interest of full disclosure, I would say that our BAC number is at and remains a .16. So I know we're talking about this 05 BAC law, but my experience, and I think the state's attorneys I see present, TJ and some others, would tell you that the average BAC is well in excess of any detectable threshold. I think the odds of anybody having a single drink by itself and getting a DUI are infinitesimal. I just, if it's not impairing and it's not outwardly measurable, it's not something that we're going to even detect or be interested in, frankly, if we do. Under the influence of drugs, however, is a different story. The model criminal instructions, and I've spoken with the author of this particular one and confirms there's really no case law for him to rely on, but simply states the proposed instruction is you are under the influence of a drug if your full mental or physical capabilities are affected. But when we talk about mental and physical capabilities being affected, we have to come back to what I highlighted earlier, which is that the impairment must render the person incapable of driving safely. So that's a different degree of impairment when you stop and you think about it. It's not impairment that someone can just see in you and say, hey, I know Bill's drunk because Bill's acting strangely and he's overly friendly, he's throwing his arm around me and he's a little bit wobbly. Now you have to show that this person would be incapable of operating safely because of the drug or drugs, plural, that they had ingested. That's where drug impairment is a different game in a lot of respects than the well-worn alcohol-based DUI that we've all, at least in the prosecutors and law enforcement, have become accustomed to dealing with. And the other issue is that since at least 1981, and likely before, but our recorded case was 81, we have State v. Rifkin, which was a case that said that you need some type of expert testimony to establish that the impairment that we're seeing in the defendant is the kind of impairment that one could reasonably expect this type of drug to cause. I think Rifkin was a marijuana case, and the officer said, well, he certainly seemed stoned to me, and Mike's earlier testimony about, you do the thumbnail comparison out there and say there's something wrong with this guy that's not alcohol related. But State v. Rifkin says that's not enough. Now we need somebody with some expert credentials to make that comparison to say that this person's impaired. So what that gives us is a discrepancy. If I'm prosecuting an alcohol-based DUI, I really only need a proof of impairment to the slightest degree. I'm doing a DUI drugs case, all of a sudden now, because the person was taking a drug instead of alcohol, I have to prove they were absolutely incapable, and incapable is an absolute word, of operating safely. I suggest what that creates in the law, not intentionally, is that drivers who drink are held to a higher and safer standard, but drug drivers can always argue that they were impaired but could still drive safely. And we see that a lot. I see it a lot. I see people say, well, sure I was impaired, but I wasn't all over the road. And if you can carry it out to your logical conclusion, and I heard this a few weeks ago in court, defense attorney said, even if my client was swerving, you still can't prove they were incapable of operating safely. And that's because they might have been able to drive straight had they focused a little harder or had they wanted to. I'm not faulting the defense attorney. It's their job to be a zealous advocate for their client, and that is the argument you logically have to make under our statute, which is, you haven't proven me incapable. Was I swerving? Sure, but that's just because you caught me at a time when I wasn't really paying attention. Maybe I was turning the radio or just wasn't thinking hard enough, or I was on my phone. But I don't think the discrepancy that exists in the statute is supported by the scientific underpinnings that got us here. So let's talk about alcohol again. Alcohol impairment gives you, it's measured in nanograms per milliliters of alcohol. And I saw Dr. Connie here, and she can, thank God there's a PhD toxicologist here. She can jump in and correct me if I get any of these facts and figures wrong. But a BAC of 0.5, which is under the 0.8 BAC, which is probably about 3 drinks in the course of an hour for an average adult male, is 500,000 nanograms of alcohol per milliliter of blood. So whenever you get your BAC report, that 0.8 is actually nanograms of alcohol per milliliter. I can tell you only that a nanogram is very, very small. I was one of those people who went to law school because they knew there was no way they were going to do anything with science. So, but what this gives us is just a baseline so we can understand, I think, the relative strengths of the impairing compounds we're discussing today. So if you got a BAC of 0.1, and this is alcohol again, we're looking at about a million nanograms of alcohol per 1 milliliter of your blood. 2 shot glasses of pure alcohol, and this is, we're talking 200 proof, which is different than, you know, what most people are drinking, we hope anyway. So 2 shot glasses of pure alcohol will put the average male at a BAC of 0.01. Now most alcohol is about 40% in strength, 40 to 50 depending on the proof, so you can do the math. It's, you know, maybe 4 or 5 shots of an average person will get you up to that 0.01. 0.1, yeah, thanks. See, there's the math thing again. So, but drug impairment occurs at far lower concentrations in your blood. For example, the million nanograms of alcohol we were talking about becomes 100 to 300 where amphetamines are concerned. So if you take 2 shots of pure amphetamines, and I don't think it comes in shot form, most people are doing it some other way, but humor me, that equivalent amount would impair 10,000 people. So what would have been impairing to one person when you add it, consider it in the effect of a stimulant drug, now we're talking 10,000. THC, which is the active drug in marijuana, 50 to 100 nanograms. So it's pure 2 shots of pure THC, the equivalent amount would be 20,000 people. So that suggests to me it's 20,000 times as potent as the alcohol equivalent. LSD, and this one's amazing, 1 to 2 nanograms. So 2 shots of pure LSD, 2 shot glasses could impair 1 million people, which is really kind of incredible if you think about those numbers. Anybody have questions about that? That makes sense? Okay. So this is the question I have when you step back and consider that. We require proof that something that's 20,000 times more potent than alcohol is not only impairing, but must be shown to be impairing to a degree which renders you incapable of operating safely. You bet it's unsafe to be impaired, especially if you took something 20,000 times stronger. And Vermont's DRE officers, if you're a DRE officer, would you raise your hand just so folks know? So some of this work was done for me. Earlier, people were talking about the drug recognition expert program. But our drug recognition officers routinely observe and document THC impairment in drivers whose blood test showed less than 5 nanograms of THC. So everybody talks about this 5 nanogram limit as being the presumptive per se threshold. Oh, if you're at 5 nanograms, you're impaired. I don't disagree, but when I had Jim Roy pull me statistics and send them to me of some of the more recent DRE evaluations that were done for THC, the officers were correctly calling impairment by THC at levels below 5 nanograms, down to 3 nanograms, 2 nanograms, 1 nanogram. So it can be impairing at exceptionally low doses. Covered some of this, but a DRE is a drug recognition expert, and an expert is someone who has scientific, specialized, or technical knowledge. So DRE officer, just so we get a sense of what they do, it is a 2-week program that they attend. It's an 80-hour coursework with testing at various times throughout. And it's not just the 2-hour class, or the 2-week class, excuse me. It's an intensive selection process folks apply but routinely don't get in, and you have to have a certain knowledge base to begin with. You have to be a graduate of the ARIDE program. You have to be a successful law enforcement officer to even be considered for the program. And then when you do get in, you participate in an 80-hour class, testing every day, 3 exams that are graded well above the curve and are not a pass-fail exam, but you've got to get 80% at least, I think, on each exam to be able to even advance to the next level. Once you've done all that, you do a 1-week field certification course, and that course you have to do 12 different evaluations, and you have to be correct in your calls on those evaluations. So what I'm trying to impress upon you is just that the DREs aren't just cops that had a weekend at the Holiday Inn ballroom somewhere where they got a certificate. These guys are expert level evaluators of drugs, and they have training, they have experience, they have certifications far beyond the kin of the average layperson. And we're getting to a point with them where they're routinely being admitted now in Vermont's courts. And I think we're up to 5 or 6 counties. We don't have a Supreme Court case yet, but 5 or 6 counties that the judge has routinely recognized the expertise of the DRE evaluator. And so in those cases, we're not having Daubert hearings anymore about, is this scientific? Is this something that we can admit to court, or is it made up? We're having hearings that are much more truncated. Is Trooper Riggin a DRE expert? Can he testify? Not does this work, but it works, so can he testify to it? Does he have the training? That's a different story, and it's really helpful to be getting to that point. But just to highlight, we have 6,000 working DRE officers on the planet, so there's not a lot. In the state of Vermont, we currently have 28, and the VSP, I think there are about 14 of those. So if you think about the troopers, and you think about the number of troopers that there are, and then you think about only 14 of those troopers have achieved the DRE credential, you start to realize it's a pretty elite. It's an elite group. It's an elite club of people who have this training. So our DREs, and you got to keep in mind there are 28. We could probably use 280, right, Ted? So a lot of what they do is limited by their geographic availability. So if you are in Guildhall and you need a drug recognition evaluator, you might not be able to get one as an officer, and so those cases don't get reported. They don't go into the statistics. But these numbers are interesting to me because they show some pretty significant things. And so in 2010, we had 113 cases where DREs were present. And again, keep in mind those are cases where a DRE was available to come to the scene. In 2011, we had 105. 2012, the number went to 160. But by 2013, 28 folks screened 201 cases. So we've effectively seen the number double in about 3 years. So again, and these are some of the qualifications. Those are cases where a DRE was available. And there are also cases where, frankly, the arresting officer, because the DRE is more often than not the arresting officer, but these are cases where the arresting officer was able to flag some sort of impairment that wasn't attributable to alcohol. One thing to keep in mind, and it's a term you'll hear a lot in the future, is polydrug. And the DUI drugs statute talks about it. It talks about under the influence of drugs or alcohol and a drug or drugs. Polydrug just means multiple drug use. So in any event, there are certainly many polydrug drivers, people who take alcohol and drugs. And the DREs don't necessarily see all of those people because if your BAC is at or above an 08, that more likely than not becomes strictly an alcohol case. And at least that's what history has shown to this point. So if you consider that, we're really getting a sense of the tip of the iceberg for the drug driving problem. So it's not just people who take a drug and drive. There are people who take multiple drugs and drive. And on top of that, there's people who drink and use a drug with the alcohol. And those folks don't even get prosecuted as a DUI drug because they have enough alcohol in their system. But of course, the question you have to ask yourself, I suppose, at that point is, how much more impaired were they because of that drug? I mean, if your BAC is a 0.1, and on top of that you have THC in your system, I think we should be really concerned about that. So I spend a lot of time on the phone with colleagues in, I guess I call them marijuana states, or states that have legalized or taken significant strides towards marijuana. And one thing I have learned from all of them is that states that have amended marijuana laws, either with decriminalization or legalization, have seen a measurable increase in drug driving crashes. One of the better studies out there right now, it's the Columbia University study, showed that about 4.2% of drivers killed in crashes had marijuana in their blood. By 2010, that number went up to 12.2. So what I've understood from particularly colleagues in Washington and Colorado who do my work out there is that when you have marijuana law changes, you see a corresponding increase in marijuana use and driving. One thing I think it's worth talking about here is drivers who say, you know, my medicine's prescribed, so it can't be impairing. And, you know, I get the argument all the time that, oh, yeah, I smoked a joint and I drove, but, you know, it's not a big deal. Well, this is actually lifted from an affidavit that I was dealing with in court. Can everybody read this? People in the back? I'll just read it aloud. I don't want to feel like I'm a drone, but so this is from an interview that it's part of a drug evaluation that Trooper Riggin did. And at the conclusion of the evaluation, the defendant ultimately admitted that he had smoked marijuana today. However, he said it was either much earlier in the morning or I think at noon and 12:30 and not recently before the traffic stop. He said he used about a bag of marijuana, and which was about a 1 gram bag, and did admit that he was impaired. I mean, he said he understood that he was impaired from the marijuana while he was driving. But this is the important part to me. Stated something to the effect of, I am impaired to the slightest degree, but I don't think I'm in the wrong because I hadn't run over any kids. So that's the attitude challenge, you know, that I get to deal with. The scenario that I always put forward is to say, when I hear the argument, my client was under the influence, but they weren't incapable of driving safely. And I think the counter to that argument is always, just because there was no pedestrian in the crosswalk and you got lucky driving through there, I don't think that means that you could have gotten lucky if the pedestrian was in the crosswalk. I think you probably would have had a real problem. And I say that because you learn about the effects that drugs, and particularly marijuana, but all drugs have on you while you're driving. So, speaking of that, and we'll go back to my stint in jail in Arizona. I've just gotten done doing the 80-hour course load for the DRE program. And I completed that, and then I had the opportunity to go out to Phoenix to the jail, and it wasn't just any jail, it was Sheriff Joe's jail on 4th Avenue in Phoenix. So that's Joe Arpaio, who's fairly notorious, I think, nationwide. You know, the reason that the classes go there is because in one night in that jail, you have an opportunity to see more people on more kinds of drugs than hopefully we're ever going to be able to see here in Vermont. So, you know, you need a marijuana guy, he's over there. You need a heroin guy, there's 3 of them. Take your pick. Yeah, and that's what the trip was for, was to see and study those folks. It was the field validation for the marijuana, or excuse me, for the DRE program. And I just want to tell everybody in the room, a lot of these folks had been in custody since 6 or 8 o'clock that morning. I mean, I don't think anybody ever gets picked up by the police at a convenient time. You know, there's a lot of guys in gym shorts and flip-flops that they put socks on, you know, and obviously had been, you know, rousted out of bed and drug into jail because they had a warrant. Some people hadn't been home from the night before and, you know, had gotten picked up at 2, 3 in the morning and had something in their possession. So we, for those 2 days, would go to the jail, you know, on a beautiful 80-degree day in Phoenix without a cloud in the sky, and it was so much, weather was so much better than here. And then, you know, you go to the jail, and the door would swing open, and you go inside, and there goes the sun, and it's all fluorescent lights. And in any event, those folks had been in custody for an awfully long time. I mean, a really long time, 14, 20 hours, day and a half, some of them. It was incredible to me how observable their impairment remained. Absolutely incredible. People that had had a joint hours ago, people that have been in custody, I know, since 8 o'clock in the morning, at 4 o'clock in the afternoon, couldn't walk a straight line. People that have been in custody since the bars closed the night before, at 4 o'clock the next day, still had issues with their eyes, still had dilated or constricted pupils, still had eyes that couldn't adjust to light because of the effect of those drugs that they had taken. So if that's the kind of impairment we see in people who haven't had drugs in their system or hadn't taken drugs recently, and by recently I mean within that day, what kind of effect are we seeing in people who just recently took them? And we, believe me, saw a few of those folks too, and that was a pretty memorable occasion to see somebody who had just taken cocaine and amphetamines and methamphetamine sort of all at once. In any event, my point is just, drugs, not only are they impairing at low levels, I was surprised how impairing they were for how long. So I think that's an important consideration to have when you keep in mind the fact that we're talking about, are there a threshold level to set? Is there an appropriate amount to set? Is 5 nanograms okay? Is it not? Should it be more? Should it be less? I would love for everybody who has a voice in that to spend the night in Sheriff Joe's jail. Eat first and bring lots of hand sanitizer, but you should try it if there's any way that you can do this. So in states with marijuana decriminalization, we see increases in the number of DUI drugs cases involving marijuana. So let's narrow it down a little bit. We'll just talk about marijuana. So this is from, and this is probably the state with the best numbers right now. I don't do as much work with Colorado, but Washington State has had this for some time. In 2009, about 18.2% of the total cases out of Washington State were marijuana. 2010, we saw it go up about 1%. 2011, another percent. 2012, came down just a little bit, but by 2013, we're looking at about a full quarter of the Washington State statistics showing that there was THC in all DUI cases, so about 1/4. So back to that issue of poly-drug use. No one is just smoking pot and driving, or very few people. It's a multiple substance problem that we're looking at. 1/4 of Washington's DUI drug cases are drivers under 21, and marijuana is more frequently detected in these drivers than is alcohol. And that's the incredible one to think about in my mind, and I think the thing that I want people to take away from this. I think we're getting to a point where, and we can fix this with our DUI drugs law, and I'm going to get to that in just a second. We're getting to a point where we've got to make sure that it doesn't make more sense to drive stoned than it does to drive under the influence of alcohol. We don't want to give you a legal incentive to smoke pot and drive as opposed to drink and drive. Hopefully we disincentivize all of it, right? So we talk about average THC concentrations. So in 2011, the average THC concentration was 6.4 nanograms per milliliter. And again, this is in Washington State. 2012, that average was 8 nanograms per milliliter. And in 2013, back down to 7.2. So, I mean, one thing to keep in mind is that those numbers are higher than you'd like to see, obviously, but the other is to think about how close they are to 0.5, or to the 5 nanogram limit, excuse me. So think about if there is a 5 nanogram limit set. I don't know the exact numbers, but if the average is 6.4, it would suggest to me that on the backside of that curve, you're going to miss some folks. So I wrote this presentation about a week and a half ago, probably, and got a phone call right about at the same time. So the House the House Judiciary Committee, excuse me, has stolen some of my thunder. But given the likelihood that marijuana will become more prevalent on Vermont's highways, I think we need to ask ourselves, do we need to rethink a public policy that permits drug impairment in drivers until such time as they become incapable of operating safely? I would suggest, and as I've suggested to the House Judiciary before, they were good enough to have me and consider our perspective, I think the standard needs to change. And with H501, which I have a draft copy of, seems to have done just that. H501 is a bill, for those who don't know, was originally written by Representative Potter of Clarendon. Is he here, by the way? I saw his name, Representative. And what the bill aims to do is to make the language consistent between DUI alcohol and DUI drugs. And what that would do would simply say, person shall not operate, attempt to operate, or be in actual physical control of any vehicle on a highway when the person is under the influence of any drug or under the combined influence of alcohol and any other drug, period. No more to a degree which renders you incapable of operating safely. No more, yeah, I was all over the road, but I could have done better. I just wasn't trying my best. No more, well, I didn't run some kid over, so hey, no harm, no foul, as the old saying goes. So anyway, H501 is in committee right now, and I believe it's been voted out. I'm not sure what the exact status is, but I know it's got some legs under it, and hopefully goes further and becomes the law. I see Representative Lippert here, who is the chairman of the House Judiciary, and I also see Representative Waite Simpson and Representative Koch from Barry, and I know that they're all involved in this legislation, and I wanted to, while I had them here, thank them for their interest in this issue and their participation and their leadership on what I think is one of the more important bills coming out of their committee this year. So everybody should contact their representative and ask that H501 be passed. So I don't really have more to add to the subject than that. I wanted to make sure anyone had questions for me about the DRE program, about DUI drugs law, the legislation. I learned from Mike Brown at a former event that we went to that you never do a PowerPoint that's more than 15 slides. And so I've tried to adhere to that today. But I know it's a more technical issue, I think, than some folks are used to dealing with, and or maybe not. But does anyone have questions, comments, anything that, yeah, Representative Lippert.
Yeah, I would like to thank you for this, but also to say that H501 did pass out of the House Judiciary Committee on Friday of the week we were finishing before town meeting week. It passed out unanimously. It is a bill that was first introduced by Representative Dave Potter, who was here from the House Transportation Committee, and I would recognize Representative Hodge and Representative Wade Simpson, who will be reporting the bill to the floor of the House. It will be up for debate and for vote on the floor of the House this week, possibly next week, depending on the internal scheduling of the House. And it is an important bill, and we do hope that you will weigh in with your colleagues, our colleagues, your legislators throughout the state, and that this time next year we'll be able to report that the drug policy in the legislative statute has changed.
Anybody else? I saw some more hands. No one? Everyone agrees completely with me that.
Right.
Yes.
How are we doing with exit orders on when it's drugs alone in terms of keeping my safety straight? Bloodshot eyes enough to get somebody out of the car.
So State v. Sprague, for folks who don't know the case offhand, is Vermont's case that talks about when an officer is allowed to detain a motorist to investigate a DUI, and it doesn't talk about alcohol or drugs. And I think Sprague specifically was a drug case, right, TJ? It was a marijuana case. That's somewhat of a gray area just because it hasn't been tested yet. One thing I know is that we don't have any case out there that says that with alcohol, we don't have a case that says that the odor of alcohol alone is enough to get somebody out of the car. And when you hear that at first as a prosecutor, you think, geez, somebody ought to take that case up and test that principle. And I think what you realize after a little while and seeing some of these DUI cases is that's probably because not many folks had just the odor of alcohol. There's always some other some other clue available to the officer roadside that would suggest to them that that person was under the influence of alcohol. And I think marijuana is the same way, and on some level. I mean, I think that the odor of marijuana alone likely would be enough to ask somebody to get out of the car. We haven't litigated the issue yet, but I think there's always something more. I think there's the eyes, there's the speech. The folks that I saw in Sheriff Joe's jail who were stoned didn't hide it as well, I think, as they maybe thought they did. I think one of the things the issue highlights, though, and you're absolutely right, is that we're going to have a lot more folks who are using marijuana and driving. I mean, I live in Waterbury, and people would get out of bed at 4 in the morning in New York City and Boston and drive to Waterbury to get in line so they could buy this, heady topper, this special local IPA beer at the Alchemist. If we're selling strong beer and people are driving 6 hours in the night for it, what's going to happen when we have a marijuana dispensary? It's an issue we're going to have to be on top of, because we're going to have a lot of folks who have marijuana in their system are up here on roads they don't know and are driving around. We're going to see more traffic stops. My conversations with folks in Washington and Colorado have said to me that marijuana particularly warrants additional officer training and investigation. Detecting it roadside is one of the more, they say that you don't see it at first, but once you understand the signs, it becomes more and more evident to you. My favorite story about it was just that somebody from the Washington State Highway Patrol told me, I go up, I get the license and the registration, I go back, I run their plates, I make sure they're a legal driver. And then I go back up to the window, and I just sort of stand, and I wait. And I see how long it takes them to notice me when I'm back at the car. And he said, as often as not, they'll have their phone out, they'll be sending the text, dude, I just got pulled over. Or they'll be playing with the radio, or, he said can be some general surprise that, oh yeah, that's right, I'm in the middle of a traffic stop. So I think that shows, that marijuana does affect the attention that you need to drive, but I think it also shows that as law enforcement folks get further into this, we're going to have to come up with new ways or more training just to recognize some of the signs and symptoms. Because I think everybody out there with a badge has seen a drunk driver. I don't know that everybody has seen a stone driver, or a stone driver with a bunch of pills in his system, or some variant of that. So we have a few minutes if anybody has any other. Yes.
The Commissioner alluded to it, but how do you feel the effectiveness of drug testing is right now in terms of your ability to prosecute cases in a timely manner?
We are a blood test state. And, Representative Lippert, you will be so tired of me at the end of 5 years with all these little issues that are going to come up with testing and 05 limits. But currently we're a blood test state, and that's great because we use a gas chromatograph to verify the blood test results. And that no one really has a basis to challenge the scientific validity of that. Mike Brown from NHTSA was talking about the oral testing that we're getting into. And that's less scientifically proven, I still think valid, but what oral testing does for us, the blood testing doesn't, is gives us a really rapid return. The blood test, we take the blood, we log it as evidence, we send it to the lab, we tell them we want X, Y, and Z drug tested, they put it in a FedEx container, it gets shipped down to a lab outside of Philadelphia, that lab does the testing, and now you've got an issue with getting an out-of-state witness here for a misdemeanor trial. And I can tell you what that costs, and I can tell you what that does to our ability to routinely prosecute the number of cases that we're going to see. If we have 200 DUI drugs cases now and are going to have 300 or 400 in 4 or 5 years, are we going to spend $10,000 prosecuting every one of those cases? So I think the commissioner is really onto something when he says our lab needs to be prepared for the challenges that this is going to make for us. So I guess the short answer is yes, I think blood testing is great and it's the best thing we've got now, but I would really like to see us get to the point where we can do something with drug testing that's a lot like the data master. You blow in a tube, it prints a number out on the ticket, I'm the prosecutor, that's my case. That saves me a tremendous number of steps. And I think when we look at the volume of these cases we're going to have, I think it's something that we need to get the ball rolling on. And it's funny you would ask that as the NHTSA regional administrator, because you're in the office where they test the data master instrument and where they have the approved testing facility for breath testers. It would be great to get something that's the equivalent for a blood test up off the ground and approved by NHTSA, because that's a really important credential for us. And in fact, our alcohol test results in a court aren't admissible unless one of the requirements is they were on a NHTSA approved device, I think is the most recent iteration from our lab. So, yeah. Any other questions? Tired of DUI drugs yet?